Chapters 2 and 3 will consider the case of Imerman and analyse the impact this had on the Hildebrand rules and ancillary relief practice and procedure. Disclosure is, of course, a major issue in many ancillary relief cases. It's not uncommon for one party to examine, copy or retain private documents belonging to their spouse in order for them to learn more about the other's financial position. Such interference with the other spouse's documents may amount to an infringement of their property rights and rights of privacy or confidentiality. The practice which developed following the case of Hildebrand in 1992 was that the family court would not penalise the taking, copying and immediate return of documents, provided no force was used to remove the documents, and that there was no interference with any hard disk or electronic equipment. Even documents wrongfully taken would be admitted in evidence, as there was an overarching duty on the parties to give full and frank disclosure. The headline outcome of the Imerman decision by the Court of Appeal is that the Hildebrand rules no longer apply and provide any protection. There is no longer any justification for a spouse to examine, retain or make copies of financial documents where such a document was confidential to the other spouse. This would constitute an actionable breach of confidence. The change in the law ushered in by Imerman is complicated and still working itself out. In the meantime, practitioners must apply the judgment as best we can. If we turn to look at some of the facts, the husband in that case worked and shared a computer system with his wife's brothers. At least one of the brothers copied documents from the husband's computer and forwarded them to his solicitor. He sifted out the privileged documents before passing the rest on to the wife's solicitors. This occurred before the obligations of disclosure in Form E had arisen. The husband obtained a civil injunction against the brother's solicitor before Mr. Justice Eadie in the Queen's Bench Division. However, in the Family Division, Mr. Justice Moylan made an order permitting the wife to retain the documents, subject to the husband's solicitor confirming that there was no privileged documents therein. The Court of Appeal confirmed Mr. Justice Eadie's order, while amending Mr. Justice Moylan's order so as to require the wife to deliver all copies of documents to the husband's solicitors. This decision was taken on the basis that the taking of documents had been contrary to the civil law of confidence, as set out in the decision of Douglas against Hello. It was concluded that it was arguable the brothers had committed a criminal offence under the Computer Misuse Act 1990 and acted in breach of a data controller's duties. However, it was not necessary to make rulings on those issues at the interlocutory stage. The court held it would be a breach of confidence for a defendant without the authority of the claimant to examine or to make, retain or supply copies to a third party of a document whose contents are or were or ought to have been appreciated by the defendant to be confidential to the claimant. That can be seen at paragraph 69 of the Imerman decision.